tent after he struck the two bicyclists and then coasted for the 1,500 feet. The car was disabled. He stopped. He told, and this was not presented to the grand jury judge, a witness came up. He said that Mr. Higgins told the witness that he was the driver and that he had been drinking. That witness told him, I'm looking back to see, I see bicycles over there. At that point, Mr. Higgins did not know that he hit a person or two people. It's in his statement, Judge, to the police that when he first hit it, he did not know what he hit. One of the elements, and an extremely important element to leaving the scene of an accident, is knowingly leaving a scene where you've caused the death of somebody. Mr. Higgins realized after he had stopped that he had hit the two bicyclists. Now, he was 1,500 feet away. The statute doesn't talk about go out with a measuring stick or a wheel to find out how far away you were. It's just you have to stay at the scene. Well, we all know that Mr. Higgins stayed at the scene. There's body-worn camera videos of him performing standardized field sobriety tests at the crash location, Judge. But he was 1,500 feet away. What the state presented to the grand jury was that he intended to leave, and there's zero evidence of that. The witnesses didn't testify to the fact that he got back into the car to go, that he had called for a ride, that he was walking away. And in fact, Judge, as we know from the discovery in the case so far, because Mr. Higgins had told the troopers this at the scene, he had had surgery on his knee that week, and he had stitches in it. So to walk back another quarter of a mile or so to get back would have been very difficult for him. But he was back at the scene, Judge, did his best to perform the field sobriety test, but all of that information was not presented to the grand jury. The state's case lacks that element that Mr. Higgins knew at the time that he hit a person or people, and he didn't know that, Judge. And because of that, the state's presentation on that count fails. Judge, as I said, this is a situation where the court needs to focus on the duty of the grand jury acting as a shield and as a sword. And those are put in place, Judge, the shield to protect those who are accused of crimes from overreaching by a prosecutor. Judge, I submit that the fact that the state did not present the elements completely means it did not present a prima facie case to the grand jury, which means the indictment is palpably defective and must be dismissed, including the counts, especially 3 and 4, Judge, and then 6 as well. Thank you.
Thank you, Mr. Yes. Thank you, Your Honor. I just want to, I beg Your Honor's indulgence. I'm pretty much going to read the law to Your Honor, because I think it's important to lay that foundation for what I want to go through. These motions to dismiss are fairly commonplace. The law is pretty settled on that, but I did want to lay that foundation. There are only limited circumstances where an indictment can be overturned. Those circumstances are when the indictment is manifestly deficient or palpably defective. When these circumstances are met, dismissal is only appropriate when the grounds are described in the clearest and plainest. Also, where the indictment alleges all the essential facts of the crime, the charge is sufficiently stated and the indictment should not be dismissed unless its insufficiency is palpable. To uphold the indictment, the state must prove or present prima facie evidence to the grand jury. In reviewing the sufficiency of the evidence, every reasonable inference should be given to the state. The evidence presented does not need to be sufficient to sustain a conviction. What we just listened to is great evidence for a pettit jury to hear in closing argument, but it's not what is necessary for a grand jury. Grand jury is a process, is not adversarial. Evidence presented only needs to be sufficient to establish a crime has been committed. not establish guilt or innocent. Any challenge to the indictment must demonstrate the evidence is clearly lacking to support a charge. Because of the non-adversarial nature of the grand jury proceedings, incomplete or imprecise legal interpretations will not warrant dismissal. Indictment should not be dismissed if the grand jury heard at least some evidence as to each element of the offense charged in the indictment. Again, I do agree with counsel when he indicated that the state cannot present half truths to the grand jury. That is not what happened here, though. The grand jury presentment was 2.5 hours long. It encompassed 2 witnesses and 14 exhibits. I believe there were 12 photos, half of which were the defendant's Jeep. The other half were John and Matthew's bicycles after the defendant had run over them. And the other 2 were the diagrams that were developed by the state police when they were doing their review of the crash scene. So the grand jurors had those documents to review when they were doing their deliberations. I'll start with the arguments that there wasn't enough evidence to support a finding of the extreme indifference to human life. What was presented to the grand jurors was that the defendant was intoxicated when he was operating his Jeep on the day in question. They heard testimony where the defendant admitted to this multiple times to multiple people. There was field sobriety tests where he failed them. Trooper Alenardo smelled alcohol on the defendant's breath, and they did a blood draw on the defendant, and it came back as a 0.087, which is above the legal limit. He was operating this in the vehicle while intoxicated, and he came up upon the Ford Focus, and he came up and the driver of this Ford Focus noticed the defendant because she said she was driving at 50 miles an hour. We know that because that's what she said in her statement. And the speed limit on that road, which was testified to, was 50 miles an hour. I believe that was all testified to at grand jury. The defendant would come up on her bumper and then pull back, and then go back on her bumper and then go back. It happened about 3 or 4 times, and then the defendant passed on the left. Again, there was no insinuation that the defendant wasn't allowed to do that. And then when he was doing that, the Bronco had seen the brothers and was moving over into the oncoming lane to give enough room to the brothers so they could safely pass, which they were allowed to do and which they should do. Oh, and by the way, it was dark out, which would mean that you have to be even more cautious on a road like this. So the defendant, wanting to pass both vehicles, goes into the in between both vehicles and wants to pass the Bronco. And that's when he strikes John and Matthew. And he keeps on going. There's testimony that the defendant indicates that he keeps on hitting the accelerator when his car stalls because the front driver's side or passenger side headlight is dislodged. It dislodges from the wiring, and he can't get it started. He's trying to start it up again, and it coasts to a stop, not 0.2 miles away, but a quarter mile away, over a quarter mile away, actually. And what does he do? He doesn't call 911. He doesn't talk to a 911 operator. He gets rid of the alcohol, the unopened alcohol and the open alcohol containers that are in his car, the evidence of his intoxication. And he calls, I believe it's his parents or his wife. He makes phone calls and talks to other people. when he passed the Bronco.
All right, we're going to pause it right here. So think about what this is about. The defense here is trying to say that there is some liability with the Gaudreau brothers, because we know this is a homicide by vehicle while DUI case that's being alleged against Mr. Higgins. And his attorney is trying to say that the alcohol consumption by the Gaudreau brothers could be a contributing factor. This is like a law school problem. Let's bring in law professor, criminal defense attorney, and former prosecutor, Cynthia Armijo. Great to see you, Cynthia. Oh, I know you know how sad this is, and I keep thinking about how Johnny Gaudreau's wife, Meredith, just had their third baby on April 1st. Baby will never get to meet dad. Legally, and this happened a couple days ago, full disclosure, we're not trying to hide the ball with anyone. We know, the judge is moving this case on forward and not finding that their consumption has any bearing on the case moving forward and continuing. Do you think the defense is right, or even has to be bringing this up in order to not be considered ineffective?
So that's an excellent question. So you usually see these kind of arguments in civil cases, comparative negligence, if somebody contributed to somebody else's injury, but the person that was injured also had a part in it. Usually see it that way. But in this case, this is a criminal case. And the defense attorney brought up some really good points about possible exculpatory evidence, possibly evidence that might be used by the defense. It's kind of a long shot, to be sure, but certainly if it's exculpatory under Brady, it should be provided.
Appreciate it, Cynthia. Yeah, I mean, I want justice for the Gaudreau brothers. I think everybody does. This was horrible what happened to them. And defense counsel handles things quite delicately in this hearing, as you will see, trying to make it clear that while they're not trying to cast any blame, that this was awful, it shouldn't have happened, they seem to have to raise it. Just because of the position they're in advocating for their client, Mr. Higgins. Now that the judge is saying, okay, this case isn't going to get kicked, it's moving on forward. Cynthia, do you think this guy's going to want to try this and go in front of a jury, knowing who the victims are, beloved hockey stars, especially Johnny, known as Johnny Hockey?
Yeah, I think it's going to be difficult to find a jury who hasn't heard about this case, who doesn't know about it, who can be fair and impartial. Certainly a change of venue might be appropriate. However, I don't know that you're going to be able to find a place that hasn't heard of this case. So it would be a rough case to proceed on. Yeah,
most definitely. Our hearts go out to the Gaudreau family, that precious baby being born without her dad here. Cynthia Armijo, thank you so much. Stand by kindly, please. More of the hearing when we come back. Welcome back to Court TV Live. I'm Julie Grant. I want to turn to a big case in New York as Sean Diddy Combs will be appearing in federal court this morning. He's seeking a delay in his upcoming trial. His attorneys, they want a 2-month delay of his May 5th trial date where he's accused of sex trafficking. They're saying that they need the time to better prepare Diddy's defense. His lawyers said in a letter to the court that prosecutors have been slow to turn over evidence for review, making it hard to be ready by the 5th of May. Prosecutors are opposing that request. The judge said he'll be addressing it at today's hearing. Combs has pleaded not guilty to all of the charges. Turning now next door to New Jersey, where a big motions hearing happened for defendant Sean Higgins this week. This guy's accused of allegedly driving drunk and killing NHL star Johnny Gaudreau and his brother Matthew Gaudreau, who also was a well-known hockey player. They were riding bicycles at the time they were killed, and Higgins was in a car. And he told officers at the scene that he was trying to pass another vehicle when the accident happened. The brothers were in town for their sister's wedding. Let's go back into the courtroom now.
Bronco, you got witnesses in the Ford Focus that say he was speeding. The witnesses in the Bronco testified to their speed that they were going. They were all going the speed limit. The defendant was passing both of these vehicles. So anyone can infer that if someone's going 50, have to go faster to pass those individuals. So he was speeding at the time of this incident. And so when he was passing them, he was speeding. Now, there's much, I guess, that was written about the difference between the 3,000 feet between where the cruiser stopped when the troopers did their analysis of how far the defendant would have stopped if he didn't stop his vehicle where he did. When they did their initial analysis of the defendant's vehicle, they found that even though the car stalled, the car still could steer and the car could still brake. So he could have immediately stopped when he struck the brothers, but he chose not to. He continued to go as far as he could, and when he realized that he wasn't going to be able to get out of this situation, he pulled over. And it's a reasonable inference that he realized that he's intoxicated, he ran into somebody, and he has alcohol in his car. So he pulls over and gets rid of the evidence. There's enough there to show that he was exhibiting an extreme indifference to the value of human life. Now, I understand the facts of Radda's will are what they are, but the court said what the court said. And it said, a jury may infer that an individual who drives while intoxicated is consciously disregarding the risk of an accident and acting with an extreme indifference to human life. And he's talking about pedicures. So a grand jury can do the same thing. It went on and said that if someone leaves the scene of an accident, when someone flees the scene of a collision without stopping to determine whether he could render aid to any of the victims, provide additional support for the conclusion of the acted, I'm sorry, let me rephrase that. When someone flees the scene of a collision without stopping to determine whether he should render the aid to the victims, that provides additional support for the conclusion that he acted with extreme indifference to the human life. That's kind of what we have here, Your Honor. The grand jurors can find that all of this supports a finding that the defendant acted with extreme indifference to the value of human life. Whether that's supported if this case goes before a petit jury, that's left for another day. But there was sufficient evidence presented to the grand jury. With regards to the diagram and the photo and what was or wasn't on the Jeep, there was testimony regarding the weather conditions at the time of the accident. I believe it was Trooper Alenardo that indicated it was dry at the time of this accident, so that there wouldn't be any tire marks on the ground, and there wouldn't be any grass on the vehicle. And if the grand jurors, if they had any questions regarding that, they had an opportunity to ask questions. And I know Your Honor read the grand jury transcripts. They did ask questions. They were not passive in this presentment. If they had questions regarding something, they did ask questions. Regarding the diagram is what the diagram is. If counsel has questions regarding that, they can ask on cross-examinations regarding that diagram. But it is a tool, it's not hard and fast. We have eyewitnesses that will testify to what they saw on the night in question. We have the driver of the Ford Focus that saw the defendant. We have the three witnesses in the Ford Bronco that saw what they saw. Now, with regards to the intoxication, and it was a puzzling argument when I read the defense's brief, in that defense indicated that the DWI statute should have been read. But then once you dive into the DWI statute, it doesn't apply because Matthew and John weren't driving a vehicle. They weren't driving a motorized bicycle. It was apparent through the photos that it wasn't a motorized bicycle. These was pedal bicycles. But then if you look, Your Honor looks at the brief, I believe it's their last paragraph, the last full paragraph of the brief. It says this is clearly not an argument that simply because the cyclists were intoxicated that somehow exonerates Mr. Higgins by way of an affirmative defense that the indictment should be dismissed with prejudice. Which everything before then indicates that. So I was kind of perplexed. So if that's true, then the arguments beforehand hold no water, in that it's not an issue, the intoxication. They did cite the law division case, and I provided you with the rebuttal to that is the other two law division cases that did an extensive analysis of the DWI statute and came to a different conclusion, in that there is no cycling while intoxicated statute. There's no way that anyone can be charged with that. So it's not relevant to the presentment and grand jury. With regards to leaving the scene of the accident, there was ample evidence that the defendant did leave the scene of the accident. Counsel kind of read the statute, but didn't read the entire statute with regards to that. I'll read what was read to the grand jurors. This comes from what's read to pettit jurors in every case that's presented where leaving the scene of the accident is a charge before them. In order for the state to establish this element, the state must establish probable cause that the defendant did not fully fulfill any of the following obligations that New Jersey law places on a motorist who is involved in an accident.
All right, let's pause it here. So the defense trying to get this indictment thrown out, saying that when it was presented to the grand jury, they should have known that the Gaudreau brothers, had alcohol in their systems. Let's talk about this a little bit more. I'm being told we want to hit a break. Okay, let's hit the break. We'll talk about more on the other side, because this guy was offered a plea agreement and he turned it down. Stay with us. Court TV Live continues.
A cult mom is now lawyer Lori.
She's representing herself.
On charges of conspiring to murder her fourth husband.
She said, I can murder you now.
The cult mom conspiracy trial continues Monday morning on Court TV.
ENWSL is on ION. Barbara Banda and the Pride battle the Spirit.
Kick it in the box!
Then Lola Bonta and the Current take on the Dash.
What a strike!
Coverage starts Saturday at 5 p.m.
ION, it's on.
Welcome back to Court TV Live. I want to let you know that this morning a trial date was officially set for defendant Maxwell Anderson. This guy's accused of murdering 19-year-old Shade Robinson. He was in court for a pretrial hearing this morning. He's accused of not only killing her, but also dismembering her body. After the two of them went on a first date, police say he also left her body parts scattered around the city of Milwaukee. His trial date is now set for May 27th. Oh, what a case that will be. Our hearts go out to the Robinson family as they continue grieving the loss of their beautiful daughter. What we want to do now is go back to that hearing in New Jersey we've been talking about. This is a tough one for the Gaudreau family to be put through this. The defense team just doing its job, trying to get the case thrown out, making arguments that not everything was presented to the grand jury, namely the blood alcohol levels of Johnny and Matthew Gaudreau, who are the victims in this. Let's go back in.
Her vehicle at the scene of the accident. He did not do that. He stopped his vehicle over a quarter mile away, and he only did so because his vehicle wouldn't drive any further. Or immediately stop his or her vehicle as close to the scene of the accident as possible and return to the scene of the accident. Well, he never returned to the scene of the accident. He remained at his vehicle a quarter mile away. Whole purpose of the statute is to render aid to somebody that is injured in this accident or to remain on scene to help out anybody that needs help. And he did not do that. And 3, report all necessary information to appropriate authorities in a timely manner. He did not do any of that, Your Honor. A motorist who fails to fulfill any of these obligations leaves the scene of an accident under circumstances that it violate the provisions of NJSA 39:4-29. However, the state need not establish that the defendant know of his or her legal obligation to stop at or near the scene of the accident and report all necessary information so long as he or she knew that he or she was involved in an accident. So all he needed to know was...
Okay, so we know, again, this case is moving on forward. We're just spending some time on it because it's an important case. The way in which these young men, these talented superstars were killed is so tragic. And the defendant was a corrections officer in New Jersey. So if he did what police allege he did, if he did drive drunk, of all people, he should know better. Let's bring back in attorney Cynthia Armijo. She's also a law professor in addition to being a defense attorney and a former prosecutor. Cynthia, this guy was offered 35 years to plead to charges with respect to both of these victims. He rejected the 35 years. What do you think of that? Do you think that was a fair offer to extend?
I think given the facts of the case, absolutely. That sometimes people won't take a plea because it means that they would lose their job, but you're looking at 35 years anyway, so you're going to lose your job anyway. And sometimes corrections officers are a little bit concerned about doing time because they are often a target while they're in custody. That might be the reason why he rejected it. But either way, I mean, based on the information that the prosecutor presented in this case, it sounds like they have a pretty good case.
I think so too, Cynthia. I'm wondering what comes next because this guy, as you know, could have some civil liability too. I don't know if the Gaudreaus have thought about suing him, but it seems to me that even if he gets through this criminal case the way he wants it to go, his legal problems won't end. What do you think would be his smartest move? Sean Higgins, if you were advising him going forward.
I'm somebody that likes a good trial, but in this case, I mean, unless the prosecutor just drops the ball completely, the prosecutor seems to be pretty experienced and knows what he's doing. So I would say maybe a plea would be appropriate, certainly a no contest plea, because if he pleads guilty, that could affect his civil liability as well. I think it would probably be appropriate to do a plea.
Oh, such smart analysis from you. As always, Attorney Cynthia Armijo, thank you so much for everything this morning.